The theme for today's show is preparation. And quite honestly, I shouldn't be throwing stones in glass houses. It is Saturday, March the 28th of 2026, and this is the Court Gallery. Welcome back to the channel, Court Watchers. Today we have a packed compilation of intense courtroom moments. We've got Judge Mogen absolutely tearing into an unprepared prosecutor, a reckless driver who blew off court for years, finally facing a furious Judge McNally, and some wild online drama spilling over into a protective order hearing in front of a very frustrated Judge Rossi. You do not want to miss a minute of this packed presentation, ladies and gentlemen. Grab some coffee. We're just getting started here. And we have a full 2 hours until we regain normality. The cases are long, the frustration is palpable, and it all starts right now.
Record in the matter 23 CF 59, State of Wisconsin versus Danielle Rodriguez. Appearances are everybody appears by video conferencing. The court has approved that. We have Danielle Rodriguez appearing from Tichita Correctional Facility. We have her counsel, Jeffrey Jensen. We also have Special Prosecutor Benjamin Webster, who is taking on prosecution in this case over from Burnett County District Attorney. We're set today for a motion hearing, a defendant's post-conviction motion to modify the sentence. The court has received and reviewed the memorandum and motion thoroughly. I have also thoroughly reviewed the transcript from the sentencing hearing. I believe that was all that was sent to me to review. Mr. Webster, did you file any brief or anything of that nature?
I didn't, Your Honor. I still had some questions actually regarding what was raised in the defense's motion. Specifically, I know there was reference to these, I believe, 500 pages or more of medical records for the defendant. There are allusions to that. Certainly, there was a reference to potentially the court reviewing those in camera to the extent that there may be records that are of a confidential nature that would not directly relate to this matter. I do think that that information would be necessary before even I would be able to adequately respond here, because we have allusions to the possibility or speculation perhaps that this brain lesion that is referenced in the defendant's motion would cause sufficient issues to warrant a new factor, to be considered a new factor at this point. And I don't know that we have enough information to even be able to respond to it just based on the reference that it could represent a new factor. I don't know what the nature of the brain lesion was. We don't have access.
I'm going to stop you right there. Then why didn't you file anything, Mr. Webster? You've been appointed since February 17th. It is now March 23rd. Why are you so untimely?
I apologize, Your Honor. I know this was a matter as well that we were taking on and trying to get up to speed on as well. We recently had obtained the transcript as well. You
could have just easily filed a motion and said, I need more information. I can't provide any analysis or any response unless I have information.
And I was recently able to speak with Attorney Cabranes as well. I had not had an opportunity to do that previously, and part of that is just unfortunately a function of timing and caseload, but I do apologize for not previously referencing that with the court.
You're
Um,
talking to a judge who has the third highest caseload in the state of Wisconsin per judge. I got it done. I got it done a long time ago. I get all of my stuff done. And I don't want to hear your caseload versus our DA's caseload or anything like that. That is an assignment of you. You knew today was the day. We now have people here. I've had to have contact with the prison so that we can arrange Ms. Rodriguez to be here. And you're telling me you're not prepared or you didn't have enough time to quickly file a one-page motion?
And I apologize, Your Honor. I certainly am not intending to waste the court's time in any capacity here. It's just trying to, again, be brought up to speed on my end. The other concern I have for today's hearing is in regard to victim notification. In looking at our file, I don't know that our victim witness office had directly notified victims prior to this hearing. Upon realizing that, I did ask our victim witness coordinator to attempt to make contact with victims, at least I believe family members here that perhaps had been involved at the sentencing hearing. It's my understanding that they were only able to leave a voicemail for those individuals and were not able to directly speak with them. So unfortunately, I'm not able to verify at this point notification of those individuals.
Again, dropping the ball. This has been set for a very long time, a very long time. And what I'm hearing is that your office has not been doing what they need to do. This has been sent since February 12th. Notice has been set. It was sent out a long time ago. You were appointed February 17th. Any time in there, if this date didn't work, you could have simply wrote a letter to the court and said, we need a new date and time. Oh, and by the way, I need more information. I can't make any analysis and I can't make any arguments for or against. Mr. Jensen, we're here. This is your motion. If they don't have the ability to respond or to provide a defense or an argument, I mean, what do you think?
Well, you beat me to the draw on that, Judge. That was going to be my exact point, is the state hasn't filed any kind of a response, so I had no idea what their position was here today, what I would, what the contested issues were. Sounds like they are contesting whether or not Ms. Rodriguez has this brain lesion, and like I alleged in the motion, I do have the medical records, under local rule 203. I'm not supposed to just start sending those around to people or filing with the court. So I was waiting for some direction from the court to see if there was an issue about that. Second of all, I'm not sure how Mr. Cabranes has the idea that his performance is being questioned, because the exact opposite is what I argued in my motion. I argued the evidence is newly discovered because, according to my investigation, Mr. Cabranes never got the records from Mr. Cueto, and Ms. Rodriguez never discussed with him this medical issue, so he was in no way ineffective, which means that this evidence is newly discovered or is a new sentencing factor. My temptation is to say that the state has utterly failed to join issue here. The court should just grant the motion, and we should set it for a resentencing hearing especially if the victims are not prepared to give their input. But I will leave it up to the court's discretion how you want to proceed. If we have to adjourn it to give the state time to respond, then we do, and I can just get an extension from the Court of Appeals.
The state should have responded. Anything. 3
And Your Honor,
sentences.
I apologize. I think I can certainly respond to the information that we have at this point, which would be to say, I don't believe that there is sufficient information to warrant a new factor at this point, given the fact, first of all, that Attorney Cabranes did take over this case from a previous attorney. That was why I had invited Attorney Cabranes to appear today as well, because ultimately the defense's motion does alternatively argue for ineffective assistance of counsel here. I believe it's section C of his motion.
It does, it
Um,
says, or in the alternative, if you don't find that the helper, I read it, so I know it.
And based upon that, it looks to me like they are saying, even if the court doesn't believe that there's a new factor here, that there was some ineffective assistance of counsel that occurred because Attorney Cabranes did not raise this. Ultimately, I believe the burden would be on the defense in terms of a Mockner hearing, but we can certainly call Mr. Cabranes at this point if the court would allow testimony, at least on that end, to determine what information he had or did not have and what the nature of his conversations were with the defendant at the time. Of course, that does implicate attorney-client privilege issues, but to the extent that that would be waived with an ineffective assistance of counsel claim, I think we could at least address that.
Mr. Jensen?
My main contention here is that the brain lesion information is a new sentencing factor. I wasn't sure how the state would respond to that. They may have said, oh, Mr. Cabranes knew about it and decided not to use it for whatever reason. I don't think we need to take his testimony because I think it's pretty clear based on my understanding of what happened here. It's a new sentencing factor. That was a completely in the alternative argument that we put in there.
I'm gonna tell you, every defense lawyer does it. If you don't find this, court, please find this, because we're looking for everything that we can get. Any possibility to get the outcome we're looking for? Well, I can tell you what I know in this case, and I know it well. I did the sentencing hearing. I know I didn't order a PSI, so I didn't have any health information other than what may have been said or argued to the court. I don't know what Mr. Cabranes knew or what he didn't know. And I only have information about these alleged medical issues as what is stated in the motion to modify sentence. I don't even have an affidavit, a signed affidavit from Ms. Rodriguez even telling me that she does have it. I don't really have anything. I have nothing to go on from either side. So, I mean, I don't have a signed affidavit, Mr. Jensen, nothing even from Ms. Rodriguez to even swear to the court that she has anything. I don't have any medical records. All I have are these statements that are made from you indicating that she has something and the court should take leniency or be empathetic because you believe that this would have affected how the court sentenced her.
I followed the Supreme Court's direction in State versus Allen and State versus Love that when you file a post-conviction motion, you make allegations of fact. If I can get an affidavit or I can present testimony, but in the motion itself, I think it's sufficient for you just to allege based on your investigation what the facts are, and then we present the evidence. I certainly can present the testimony from Ms. Rodriguez.
Well, what did either of you think we were doing here today?
I was not sure because there was no response.
For real. Like, we are set for a post-conviction motion hearing. I'm set to hear arguments because I have a deadline. I'm told I have a deadline to have my decision done by. And so I set a hearing in February. On February 12th, everybody gets notice. Everybody gets notice of when this hearing is. It's been on my calendar. And I get here and I don't know, nobody knows what they're going to do. I don't have any witness except I guess I have Mr. Cabranes, who may testify for Mr. Webster. I don't know. I have Ms. Rodriguez. I don't have a doctor. I have no medical records. I have nothing in support of anything, either for the defense. So all I have is going off of the state and what the state's arguing. Yep, I don't think they've met any criteria, which could have been done in a written brief and filed with the court prior to, and I could have wham bam did a decision and said, sorry, no hearing. But yet we're here today and we're doing nothing.
And I apologize, Your Honor. I was also unsure when we were coming into this hearing, specifically what other information might be addressed or produced by the defense. I agree with the court. I should have potentially filed an additional motion just indicating that this was insufficient information from the defense. But my intent today was to essentially argue that we don't have enough information based on what they provided to rise to the level here of a new factor, certainly for the court to determine that resentencing is appropriate. I would note, based on my communications with Mr. Cabranes, I would stipulate it doesn't sound as if he was aware of this medical issue at the time. And so if that saves the need for his testimony in the future or today, I think I would certainly agree to that based on the information that I received from him. However, I still think that in regard to what the actual medical information is that the defense is alleging, without even the court having the opportunity to inspect it in camera, I don't know how just essentially saying that there is medical information that would show this would be sufficient at this point for the defendant's motion to prevail.
Or we could have a doctor testify, but we don't have a doctor. The only one that
I don't
I've
think we
seen,
need-
other than Mr. Cabranes, who you called Mr. Webster to be here to testify for the state, I guess, I have Miss Rodriguez. So Mr. Jensen, this is your case. This is your day. Go ahead. You want to call Miss Rodriguez?
I will call Ms. Rodriguez to testify to the factual allegations of our motion. And then I would ask the court how you would like me to file the medical records, which I do have. It's not as though I don't have the medical records. I just they couldn't have been filed electronically because it's more than 10 megabytes. And I didn't want to just start sending, USBs with medical records, around to clerks and prosecutors and things like that.
But
So
do you know what I like as a court? And I'm not sure if any of you are aware of this, what judges like, to have the information before the hearing. If that is what you're doing, that's evidence. I have no evidence. I have no medical records. I have no request for you to grant you any additional time other than today. Today is the day, is the day, is the day. So Mr. Webster has stipulated that that Mr. Cabranes was not aware of the medical issue at that time. So Mr. Jensen, I'm releasing Mr. Cabranes. So that means that he wasn't aware. He did not know.
right, that was my understanding too, because I exchanged emails with him.
All right, Mr. Cabranes, thank you so much for your time. You are released. You are not needed. You were not aware.
Thank you, Judge. Have a good day.
You too. Ms. Rodriguez, please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you may begin.
Ma'am, state your name and spell your complete name for the record.
Danielle Rodriguez, Rodriguez.
And Ms. Rodriguez, where are you currently housed?
Cachita, Fond du Lac prison.
And you are the defendant in this action, correct?
Yes.
And on March 31st of 2023, you were charged with first-degree reckless homicide for delivering drugs in the jail, correct?
Yes.
Who were you first represented by? Let me ask it a different way. Were you represented by a person by the name of Bernardo Cueto?
Yeah, Bernardo Cueto was my first attorney, and then John Cabranes was the second one.
John Cabranes, okay. You eventually reached a plea agreement with the state, is that correct?
Yeah.
Do you remember the terms of the plea agreement?
I mean, not offhand, I don't remember.
Well, the bottom line was you entered a guilty plea to second-degree reckless homicide, correct?
Yes.
During the time you were represented by Mr. Cueto, did you have a conversation with him concerning your medical history?
Yes.
And what is your medical history?
I have some brain lesions and like I have a AVM. It's arteriovenous malformation. It's like a cluster of blood vessels that are inside your head that like they blow up when your blood pressure is really high.
And when did you develop that medical problem?
I'm not even sure. I'm not sure the exact date. I don't know. I've always had like head issues with my head. I've always had like migraines and stuff.
All right. When did you start seeking treatment for this problem with your head?
I don't even know. I'm not sure. I'm not sure of the exact dates. I know, the first time I was in the hospital was Spooner Hospital, and then, I had to get transferred to Sacred Heart, which is now closed down. And then I've been in the hospital in Green Bay at St. Vincent, but I mean, I'm not exactly sure like what year or what day. I don't know. I'm not sure positive about that.
Okay, what health situation prompted you to seek treatment?
Cause I was sick. I was really sick and I had to call an ambulance for my mom's and that's how I found out I had this stuff in my head.
So is it true that in December of 2020, you sought treatment for severe migraine headaches?
Yes.
Is it true that on March 13th or thereabouts of 2022, you again sought medical help in Spooner?
Yes, I think so. I'm not sure the dates. I don't have no papers, nothing that has the dates on it. I don't have the medical records.
Right, I understand that, but I'm asking you what you recall about all this. And do you recall an incident where you fell asleep in your running van in a parking lot for about 5 to 6 hours?
Yes.
And when you tried to get out, you fell down and you could not walk properly due to weakness in your legs?
Yes.
And is that when you were diagnosed with this TIA that you mentioned a minute ago, a transient ischemic attack?
That's what I thought it was, but I don't know, I went to the emergency room and they didn't really do anything for me. They just sent me home.
All
So
right,
I'm not
well,
sure what it was.
yeah, I'm not expecting you to tell me what your diagnosis was or anything of that nature, but what I'm expecting you to tell me is how these problems, these medical problems, whatever they were, affected your ability to function in the community, okay?
This is frustrating because I thought the motion, I'm just gonna say the motion, I thought it was a motion to appeal it because the factors were that the judge thought I was available for programming and I'm not. I thought that's what we were going over here. I didn't think we were doing the medical stuff. I don't.
I need one person to talk at a time, and if Ms. Rodriguez would like to say something, it is her case.
Sure, go ahead then.
I'm just saying, like, so the post-conviction motion, when I had court, you get the paper, they tell you, you have 20 days to fill this out. I filled it out. I didn't really know what I was doing, but I just wanted to do it just in case. John Cabernet, or whatever his name is, he did know about my medical stuff. I told him about it. He was supposed to get the medical records from Bernardo, and it wasn't like, that's not why I was doing the motion. The motion was just not because of my medical stuff, but they did know about that both of my attorneys did. They knew about it. But I thought the post-conviction motion, like, the only reason why I wanted to see if the judge could adjust my sentence was because she thought I was available for programming and I'm not. Like, they're telling me here that I can't do that. Like, I'm not available to do any type of programming so that's what I thought we were doing here.
All right.
I didn't think it was gonna be like just made about my medical issues because I didn't think that's what this was all about.
Your Honor, based on that testimony, then I will withdraw the first part of the post-conviction motion concerning new sentencing factor and focus only on the second part, which is that under the court's sentence, she was eligible for programming and is actually not eligible.
Okay. So you
And that
believe
doesn't
that the court thought that she was eligible and proved to the court that I thought that she was eligible.
Well, according to the sentencing transcript, you made her eligible for programming, but she's not.
Making one eligible for programming doesn't mean that I thought that she would be eligible. It's just saying, yo, defendant, if you want and you are able to, and the Department of Corrections says, A-okay, you can participate in early release programming. Yay, the court says you can. Now tell me, where does it say that I thought she would be able to participate? And then really, she can't. Show that to me.
Well, that is the whole point of making this motion, is to allow the court the opportunity to say whether or not that factored in any significant way into your ultimate sentence.
It did not. I'll tell you that right now. It did not.
Then that settles that issue.
I think it does. So what I'm hearing is that you would like the court to reconsider sentencing because of her health issues, which the court was not informed of to that extent because the attorneys did not inform them. But now we know that both attorneys knew, even though it was stipulated that Mr. Cabranes didn't know, but that she wants the court to have mercy and be lenient because she thought she'd be able to do early release, but she can't because of her health conditions. I don't know why her health conditions interfere with her ability to do the substance abuse programming. That boggles my mind. But she probably, she can't do any of these because of the actual conviction here, because she was convicted of a 940 case statute, 940, the second degree reckless homicide. You know what? The court makes people eligible, even if 940 doesn't allow them to make them eligible, just in case something happens. Because I don't control the statutes. I don't make the laws. That's the legislature. If the legislature decides in 2 years that it decides to have second degree reckless homicide be something that they can participate in the early release programming, they can change it and they can switch it up. The courts have to sentence and say, you know what, if the Department of Corrections or the legislature or somebody else says you would be eligible to do this, I'm saying you can. That's what the court did. So what do you want me to do? What are you asking of this court? Because I've now been giving you time on my calendar. I've read your motions. I've reread my transcript. I've heard Ms. Rodriguez. I don't know what it is you're asking of the court.
Well, the motion describes what it is we're asking for. And what it is that during the sentencing hearing, the court made Ms. Rodriguez eligible for programming, for which she is statutorily ineligible. And if that frustrated the court's sentencing intent, then the court ought to modify the sentence accordingly. Based on some comments I've heard already from you, Judge, it doesn't sound like it was an integral part of the court's sentencing decision. And so I think you should make a ruling on whether that part of the motion was granted or not. The first part of the motion is withdrawn.
All right. The court's well aware of what complies or what makes, what statutory crimes makes somebody ineligible at the time of sentencing, and that would be a 940 crime, which she was convicted of. The court did make her eligible if by chance the stars shine down and the sky opens up and the law is changed to allow her to be able to participate. The court was not going to stand in that way, and any higher beings can allow her to participate. At the sentencing hearing, the court was aware of a 940, but still said she may if something else opens up. The court did not, so I'm denying your motion. It's not a new factor. Apparently, both attorneys knew it didn't come into the court sentencing. It didn't frustrate or interfere with the ability of the court to sentence. The court sentenced what it believed at the time was an appropriate sentence. So motion is denied. Anything
Okay.
further?
No,
All right,
Nothing more
thank
from the
you.
state. Thank you.
We're adjourned.
Jeremy Javon Christian. And I have these files, 21B138966A, which is a sentencing that is to take place on a reckless driving. I also have on 21B139004, I have a sentencing date on a resist and obstruct an officer. And then I have probation violation on the operating while impaired charge. Everybody's names. Let's start with you, Mr. Gates.
Good morning, Judge. I'm asking you to back Mr. Christian, the official state your full name.
All right. Can I have, were you both in the vehicle?
Correct.
Can you both tell me your names?
Diane Barbarich.
Lawrence Barbarich.
Our son was in the vehicle too. He's away at college.
All right. So this was brought to my attention yesterday, that somehow the probation officer caught it, or the probation secretary, I should say, caught it. We had not notified the victims of their opportunity to appear here today. And she called them. And so my understanding was that you, and I want you to correct me if I'm wrong in any aspect here, that you guys wanted to appear, or I think you expressed to the probation secretary, Mr. Barbarich, that you wanted to appear in person. Is that true or false?
Well, I don't want to delay any proceedings if that's going to delay it by me not being there today. If you can proceed today, that's fine.
I mean, it's up to you. I can delay it a week or two and we can pick a day that's on a Brownstown docket day that's kind of convenient for you too. And besides, I don't know if your son was notified, if we should have notified him. And he has the right to appear as well. So I feel uncomfortable unless you tell me, Judge, my son knew and doesn't want to make a statement or what have you.
Well, he's away at college right now. And so he's
in another state.
He's in Ohio. So
the funny thing is we can Zoom with people in Alaska. I've Zoomed with people in Italy before. So if I can reschedule this is what I'm going to suggest. I'll reschedule this to my next Brownstown docket day. I will give everybody a time when they can appear. And we will go from there. And then I'm going to ask you to give me your son's address to notify him. So Heather, what if we do 2 weeks from today, which would be April the 8th?
Judge, Mr. Christian had to take off work today, and is there any way to schedule this in May when he would be able to use some of his vacation days to appear? Because he's pretty much.
I don't know if person had no vacation. I just got back to work, so I don't want to be vacation too.
well, here's the thing, Judge. We took off work today too.
Well, I did.
You guys, listen, if you guys want me to sentence today, everybody, I'll be glad to do it. I feel bad that you weren't properly notified when he finally came in on this case.
Yeah, because
And then the probation secretary explained everything, that you wanted to be here. And if you guys want to stay, if you guys want to just give me your statements by Zoom and you're comfortable calling your son and telling him he can Zoom in, I'll be happy to do this. I'm not trying to be an obstructionist here. but your son has the right to make a statement too. And if we didn't notify him, our bad. And I
Uh-huh.
want to do it right.
I mean, I would like to get it resolved today too. I could try and text him and give him,
Let's do this. Why don't you text your son? I'm gonna get off the bench. We'll take a few minutes. And you call him or text him and see if he can appear today. If he can't appear, I'm gonna adjourn it unless you also tell me he's aware and he doesn't care to appear for sentencing. Okay?
or he helped us get the Zoom app installed on the phone.
Well, let's
but-
do that. We'll see if we can get him on here.
Fine, I'll pass the case a few minutes and I'll accommodate everybody here. I'm not trying to delay anything. So that's what I'll do, okay?
Jeff,
All right, so again, I have three cases. I have people against Jeremy Javon Christian, 21B139004. That is from a date of June the 13th of 21. There was a no contest plea tendered on 8/17 of 22 to resist and obstruct an officer. Then I have the reckless driving charge that happened on June the 13th of 21. And again, on August the 17th of 22, defendant pled no contest to reckless driving. And then I also have here a violation of probation on an operating while impaired charge, which the defendant was sentenced on back on March the 17th of 21, I believe. Yes, March the 17th of 21. And then did not show up for a probation violation hearing on September 8th of 21. So I can take them in whatever order you want to go.
now, if the court wants to start with the reckless driving with.
We'll do that. And the resist and obstruct. So everybody can state their names, please. Your name, Mr. Gaith?
Good morning, Judge. Nice to get from back, Mr. Christian. Christian, say your full name.
You're Javon Christian.
All right, your names, please.
Diane Barbarich.
Lawrence Barbarich?
Adam Barbarich.
All right, so the June 13/21 incident, there was a no contest plea and then he failed to appear for sentencing at least once or twice. And so we haven't had him here, but at any rate, I did not order on that
The PSI.
I didn't order a PSI, I don't believe. So I just had a sex date so the victims could be notified. They were, and then it looked like he came in on August the 31st, but left. And then I had him set it in person. And I made a note that Diane and Lawrence Barbarich were here. Be sure they were notified September 14 of 22. And then again, he didn't show up for sentencing. So that's where we are with it. I've read the report. I'm talking about the police report. Have you?
Yeah.
All right. Anything you'd like to say?
Judge, Mr. Christian at that time had become homeless. He was homeless from 22 through 25. He was laid off. And then he ended up, there was an incident in which he was shot in the hand and he became disabled for 6 months and unable to work. Then he became laid off and actually just went back to work about a month ago at Chrysler. He does have an 8-year-old child that he shares custody with the mother. And he was financially responsible for that child, Judge. And between his lack of stable residence and everything else that can go on, I believe that's the reason why he had missed and failed to appear in that direction.
Okay. Anything else?
Just that, at the time that he took the plea, obviously, looking back now, I know it did indicate that he would maybe have pled differently, but I did advise him that we're at this point now. we need to move forward.
What I mean, I don't know what he means by that. They got him going over 100 miles an hour. And rear-ending a vehicle, an Impala, I mean, you know what? Anyway, all right, anything you'd like to say? Anything either one of you would like to say? Let's start with you, Adam. Do you have anything you want to say?
Yeah, I want to say it almost just feels like a miracle that we're alive, because I mean, I was sitting in the back seat when it happened, and I was like 16 at the time, and we were coming back from a long weekend of baseball, and we're all tired, and we're just trying to get home, have a 3-hour drive, and we're just driving in like one of the middle lanes. Maybe it's like a 4-lane highway, and I'm on my phone, just kind of leaned over in the back passenger seat, and then all of a sudden it's just big bang. And it just felt like we were spinning forever, just spinning on the road. And I don't know how we didn't get hit. It just feels like a miracle to me. And we went across, it was a lot of traffic. We went across the whole lanes and slammed into the median. And I was scared for my parents' lives. I was fine. The first thing I asked is, are they okay? And I think they hit their heads, but they were fine. Everybody was just kind of dazed. And the first thing I thought was trying to get out of the car, but our car, the door that I was by wouldn't open. So I had to get out of the door that was kind of against the median and squeeze out. And the car was just absolutely crushed, and made sure my parents could get out. And we got out, and first thing I noticed, I look at the car, and the tire was catching on fire. And I was able to put it out before it caught the whole car on fire. And, it's just like these little things like this. It's just a miracle to me, and makes me look at life completely different now. And I had no idea what happened. And we had people coming up to us, and they were saying that, this guy hit us. He was speeding down the road for miles. They knew they were going to hit somebody. And then they said he went off the road, further up the road, and somebody said that they had a kid in the back of the seat. I couldn't believe what was going on. And he took off on foot. But I mean, I don't know what to believe or anything. I was just lucky to be alive, and my parents were safe. And that's all I pretty much have to say.
Mr. and Mrs. Barbarich, would either one of you or both of you like to speak?
What does no contest mean exactly?
No contest essentially has the same effect as a guilty plea, but what it does is there's certain circumstances that it's appropriate to take a no contest plea in, and that is if there's a possibility the defendant can be sued, or if there is, which there certainly would appear to have been here, nobody really quite knew what the injuries were, but he's driving over 100, they said, and I just heard what your son said. And then the other one is if they don't have a recollection due to intoxication or drug use or whatever the case may be. But it has the same effect as a guilty plea. Instead of the judge asking the defendant questions, in this case, I would have reviewed the police report and made a determination based on that, because we have to make sure when somebody pleads to anything that there's a valid basis for the plea, what we call a factual basis.
Okay.
So do you want to say anything else?
I'm just curious why he was driving so fast, like with a child in the car. That's, I mean, as a mother,
I understand. Sir, do you want to say anything?
Yes, sir. I'm a retired Detroit fireman, 35 years. I retired as a battalion chief. I've seen a lot of horrible things. And when that happened, I thought it was over, and I was afraid. I was afraid to look in the back seat at my son. And I'm just thank the Lord everything's okay. That's all I gotta say.
Does anybody have any out-of-pocket expenses? Anything you had to pay for that was not covered by insurance?
No,
I mean, just a few days lost of work, but that's, I mean,
If
Well,
you lost any wage,
the copay or whatever for the deductible, I don't know. That's,
well, I mean, if you have any out-of-pocket, I can't order wage loss because that was recoverable through your own insurance carrier, believe it or not.
yeah,
Even though he was completely at fault. But I'm gonna let you two think about it, and young Mr. Barbarich, and I wanna do all of these at the same time. So we have on the operating while impaired, I've got multiple violations: failure to attend the scheduled probation visit on August 18 to 21, failure to attend the victim's impact panel, failure to attend the court work program on August 4 of 21, failure to pay fines and costs as ordered, failure to refrain from consuming alcohol or drugs, testing positive for alcohol on August 3, failing to clear all warrants, failing to provide verification of attending AA twice a week until an IOP, and failure to provide verification of attending and completing outpatient treatment. So I'd like to either have a hearing on those or take a plea on those, whatever he fancies. So how's he going to proceed on that?
You can't take a plea.
Is that what you want to do, sir? Since you absconded, you could get 93 days here. Do you understand that? You got to keep your voice up for him. You are presumed innocent. They have to prove you guilty, Colin Bell. By a preponderance of the evidence, you have the right to question their witnesses, bring in your own, use the subpoena powers of the court to bring in those witnesses, and the testifier remain silent. If you remain silent, that silence would not be held against you. By pleading guilty, you're giving up all those rights, and we are not going to have a hearing. You understand that? Any questions before I ask you how you plead on these?
No, sir.
As to count one, that you failed to attend your scheduled probation visit on August the 18th, 21, how do you plead?
Yes,
Did you fail to attend your probation visit on that day?
yes, sir.
Count two, that you failed to attend the victim's impact panel, how do you plead?
Yes.
You failed to attend the victim's impact panel.
No.
You went to the
Oh,
victim.
yes.
Not when it was assigned, but he did make it up. But at the time, yes, he did fail.
Did you fail to attend back when you were on probation?
No.
Or in that time frame when you were given?
Yes.
To count three, that you failed to attend the court work program on August the 4th of 21, how do you plead?
Yes.
You failed to attend the court work program on that date.
Yes.
To the charge you failed to pay your fines and costs as ordered, how do you plead?
Yes.
Failed to pay your fines and costs as ordered.
Yes.
Count five, that you failed to refrain from consuming alcohol, testing positive
Yes.
on August 3 of 21, how do you plead?
Yes.
Did you consume alcohol, say within the 3 days before that test?
Yes.
And count six, that you failed to clear all your warrants, how do you plead?
Yes.
Count seven, that you failed to provide verification of attending AA twice a week until an outpatient, how do you plead?
Yes.
Count eight, that you failed to provide verification of attending and completing intensive outpatient treatment, how do you plead? Did you fail to attend outpatient treatment?
Yeah.
Did you fail to clear all your warrants? Did you fail to attend AA twice a week until an outpatient?
Yeah.
Intensive outpatient? Anybody force you to plead guilty? Anybody promise you anything to induce you to plead guilty? Please accept all 8 counts. Heather, I need to know how much he owes on those now.
On his probation case, he has a balance of $813.
All right, now I'm going to ask And again, all of these would be deemed non-technical since you absconded. So you got 8 non-technical violations. Is there anything you'd like to say
Judge, with
on
regard,
any of these?
with regard to count 2, failure to complete the victim impact panel, he did complete that in July of 24. And then as far as the count 3, he did complete that also in 2024. He doesn't know exactly when. With regard to count 4, the issue with the unpaid balance, there is a bond posted against this case, Judge, that will hopefully clear up a majority of the outstanding balance. With regard to count 5, he's pleading guilty as charged with regard to the positive test in the alcohol. With regard to count 6, Judge, the warrants, according to Mr. Christian, he's cleared the majority of them. He believes he does have 2 or 3 or 4 that are left outstanding. And that's only been a financial issue because he hasn't worked. He's only been back for like a month. With regard to counts 7 and 8, he wasn't able to get into the outpatient treatment program because his insurance wouldn't cover it. And again, Judge, financially, he wasn't able to afford to pay for that out of pocket. He's trying to make up for whatever he was able to do now. But again, Judge, mainly it wasn't so much in front of his nose at the court other than his being financially unable to pay for these and get them cleared. It was a financial issue.
Anything you'd like to say?
And I'm still currently actively trying to get taken care of my life. As far as my license, I'm trying to get my license back, but I can't get my license back because the director driving to the year. It's the only suspension that's holding me back from getting my license. So I've talked to Secretary of State about getting handling that, and the other tickets that I have are for a driver's suspended license. So once I get my license, you go back in, license this what you have.
Well, Janine,
Elizabeth Prosecutor.
anything you'd like to say?
Yes, Your Honor, and I might be able to offer up at least a little bit of clarification, maybe even some help from Mr. Christian. So he was in front of Judge Heston. I don't know if this was already addressed, but he was in front of Judge Heston July 11th of 24. She reiterated bond conditions. He did come down to probation on July 11th. I re-instructed him in regards to his treatment, chemical testing, and I did schedule him for 3 days on the court work program. He was instructed on 12-step meetings at the time as well. So as of that time frame, he was given a court date then to come back August 28th. He absconded and the bench warrant was reissued. Between that July 11th date and August 28th, Mr. Christian did do the 3 days on the court work program.
Was she talking about, I see that she was the one at one point that arraigned him on this charge, these charges. Was that court work that she told him to do, was that on these cases or was it on a case in front of her?
Not on a case in front of her. This was addressing her bond on the probation case, which would have been this one here. Judge Heston will often reiterate probation terms as part of bond. And she ordered the 3 days on the court work program because those were the days he had remaining out of the 4 that he was to attend.
He had gone to one before that?
He had done one on August 4th, 21.
So he actually has 5 days credit coming on these.
He has 4 as far as court work program.
Plus the 1 day credit for the arrest.
He did show for 1 chemical test after bond. He was positive for marijuana, negative for all other substances, but absolutely no proof in regards to victims impact panel, 12-step meetings, or treatment.
Judge, he does have the certificate of completion for the victim impact panel.
Okay. Do you have that with you, sir?
It's in my phone, I think I have a login. I have.
I'll take it your word on that.
See.
No, I'll believe you. Folks, would you like to say anything else? Yeah, you could say something to them.
To you, I'm sorry about the event that happened. It was very foolish on my behalf. And since then, I've learned I know I do it. I had a younger child at the time, and I understand the pain, kill the younger child. I just want to say that I'm sorry.
Where are you going to school at, young man?
University of Northwestern Ohio.
Well, what are you studying?
I'm actually doing 2 degrees. I have automotive and high performance technology, and then hybrid and electric vehicles.
Good for you. Anything else anybody wants to say over here?
Yes, sir. On top of what happened to us, the defendant, he had a 2-year-old in the car, in the back seat, and he ran from the scene. I was told by civilian, bystanders. And I guess some bystanders tackled him or something that I can recall, but I can't even imagine that leaving a 2-year-old on the expressway like that and just running away. That was on top of what happened to us, but I just wanted to say that too.
Judge, I want to correct the record. Actually, his child, when he left, he wasn't running from the scene, Judge. He actually took him and they went into the ambulance and they were taken to the hospital. So I don't know where the information came from, that he was tackled, but he actually went to the emergency responders and actually got in the ambulance with his child and they were transported to the hospital.
Okay, so I want everybody to understand, unless somebody speaks up and says, Judge, we have this much coming in restitution, I'm not going to order any. Does everybody understand that?
Yeah.
Well, I'm talking to the victims.
Yes,
Yeah.
sir.
All right, and you understand that, young man and Mrs. Barbarich?
Yes.
Yes, sir.
I don't know what to say to you, Mr. Christian. There's a whole lot of issues I have with your conduct, your failure to appear, your failure to show any respect for the court. And the more I look at this, the more I think about this, I mean, this is laughable talking about whether or not you get another day off or you have to wanted to wait till May if I was going to adjourn it past today because of a vacation. Or lack thereof, vacation time. You can't do this. You cannot do this. You cannot do this. You're driving around with a 2-year-old in the vehicle and you're acting like a maniac. And I could see the terror on their face just looking at them. And then you blow us off with probation, like I'm the kind that's going to put up with that. You blew us off, sir, and you got a big price to pay here today. I'm not going to assess any fines on the resisting obstructing officer. I'm not going to assess any fines on the reckless driving. I'm simply going to give the defendant 15 days jail on the resist and obstruct, and that will run with concurrent with 21B138482A. I'm going to give the defendant 45 days jail on the reckless, and that will run concurrent with 21B138482A. On the operating while impaired, I'm revoking your probation. You're to pay costs in the amount of $800 and serve 93 days, credit 5 for 88. If you pay 800, so if you get somebody to bring up 800 or sign over their bonds, that will suspend 18 of the 88 and you'll only have to serve 70. But you're in custody for 70, you pay 800. They will all run concurrent, Heather. Yep. You pay 800, you'll be out in 70. Otherwise, you're going to be in for 88.
Said I'll be out in 70.
70. You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand that? Yeah, we're going to let you make a phone call. I'll let you. There's nothing I'm going to do. You spat on the court. You drove like a maniac. There is nothing I am going to do to change my mind. The only thing I could do or would do, if I could, is call the legislature and tell them to retroactively make this a lot more serious, because I'm only giving you that because that's all I can give you. There's nothing I'm going to do to change, you're going to do to change my mind. So I'm going to ask you not to speak. You can talk to a lawyer on appeal if you want. You can't blow off courts for 3-4 years, and you just can't do that. So there's nothing else. Have a seat. Good luck. Thank you very much. Thank you, folks. Have a good day, and I wish you all well.
Thank you.
Thank you, sir.
Thank you, sir.
Good luck, young man. Study hard. Don't run against me, though.
Thank you.
See ya. Thanks a lot, Lizzie. Thanks.
We are here in the matter of Angela Taylor versus Paul Colby, case number 23-10503 PP. And this hearing is being recorded on Zoom and live streamed on YouTube.
And this matter comes before the court. I believe we are continuing a hearing regarding an allegation that there was a violation of the court's PPO. So, Mr. Murphy, would you put your appearance on the record, please?
Yes, Your Honor. Can you hear me okay, by the way?
Yes, I can.
Okay. Yes, Miles Murphy for the respondent, Paul Colby.
Very good. Thank you. And I do see Miss Angela Taylor present as the petitioner in this matter. Remind me, Miss Taylor, the prosecutor is not involved in this particular allegation?
No.
Okay, yeah, I don't recall the prosecutor being here previously. I just wanted to make sure I'm remembering everything correctly, because, and I want to apologize to all the parties for the delay in starting today. The previous case involved a giant contract and other matters case with about 100 exhibits that I could barely keep straight in front of me this afternoon, and stayed up till 2 a.m. reading last night. And I'm already regretting that investment of my time, but it was totally necessary if I was going to get through this stuff. So that's what delayed me, was much longer at oral argument than I anticipated there because of the complexity of that case. So hopefully we're not as long today, but Mr. Murphy, where did we leave off last time?
Your Honor, we had a hearing about a year ago in February of 25. The PPO is due to expire. The PPO extension is due to expire on April 24 of 26. We are asking that PPO be that it go ahead and expire. We filed basically a denial of any violation of the PPO, and I think it's, if the court looks at the volume of this PPO file, it is incredible how large it is. I think due to it's our position, this is a frivolous motion. It should be denied. We're also asking that the court recognize this as being kind of an ongoing, for lack of a better word, manipulation of the system. And really the focus here is the petitioner's displeasure with a Court of Appeals case involving the House, which is going to be.
That has nothing to do with this. This isn't for a PPO violation.
Yeah, no, I get it. I think Mr. Murphy's trying to say.
That's kind of wasted.
Did Ms. Taylor or, well, let me finish with Mr. Murphy, and then I'll let you have a chance, Ms. Taylor. Mr. Murphy, did we take any testimony during that last hearing, or did I just set a future hearing?
Sure. You did take a lot of testimony in February of 25, Your Honor, and then the other focus besides the House is the fact the parties have a almost 18-year-old son, and my client has sole custody, and I don't think the petitioner's happy about that either. So we ask that the
he doesn't have sole custody. I have custody.
Okay, no, hang on, Ms. Taylor. I'll let you speak up. All right, Ms. Taylor, I do recall now, and I'm paging through the file here, and it looks like I did take significant testimony about the allegations. Did I swear you in and have you testify last time?
Yes.
Your Honor.
Okay, and then Mr. Murphy cross-examined you?
Correct.
Yes.
Okay. Is there, I guess since this is your case, Ms. Taylor, are there any more witnesses or evidence you want to provide at this time?
Yes.
Okay, who would you like to call?
Robert Goins.
Okay. And is Mr. Goins present? Is he with you or is he separate?
Yes,
Is he gonna
he's
come
my
in?
tenant.
Okay. And is he on the same video as you are? Are you just going to switch it so he can testify or?
Yeah, I can switch it. I can turn it around so you can see him.
Very good. All right. That would be good. Why don't you do that? I'll swear him in and then you can ask him the questions, Ms. Taylor. Mr. Goins, would you raise your right hand, please? Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
Yes, Your Honor.
Thank you. And would you state and spell your full name for the record, please?
Robert, Robert, Goins, Goins.
Thank you, sir. And you don't have to keep your hand up anymore. Ms. Taylor, you can ask some questions of Mr. Goins at this time.
I just have a question a minute, Your Honor, if I may.
Go ahead.
This wasn't a trial hearing. I'm confused on why this has jumped to a trial when she was not prepared for a trial.
Well, I mean,
this was just a conference hearing on his PPO violation.
If I could respond briefly, Your Honor, I believe that it's teed up as a motion for an order to show cause for a violation of the PPO.
Yes,
and
correct.
So
well,
I
and
do
my
believe
sense
that-
was that I'd already inquired of Mr. Colby about this, that he pled not guilty, and that I
Nope.
set it for a factual hearing. And
No, sir.
Oh, okay. Well, believe me, I could be wrong on this because I handle about 1,000 cases at any given time, and to say that I have a hard time keeping them straight mentally, I'm completely dependent on my notes in the file here.
So, Your Honor, I
okay.
think the focus is on several allegations about a February 12 of 26 Facebook posting. That's what Angela did not like. Is that correct, Mr. Goins?
There's several Facebook postings, stalking, where he's followed us to a library, and then posted it, where he's come to the home and he's making statements in regards to how many FedEx and Amazon comes to the home. That's showing that he's stalking. He posted that on Facebook.
So, Your Honor, they're all very recent allegations about conduct in February of 26 as allegedly violating the PPO, which is due to expire in a month.
I see. And so really what today's is simply the order to show cause, where I would obviously inquire of you and your client whether you wish to enter a guilty or not guilty plea, and then presumably set a future hearing to do the facts on this. In other words, I was about to skip a step.
Correct.
I think that's correct, Your Honor.
Okay, no, fair enough. Well, I take it, Mr. Murphy, from your previous statements, that your client intends to enter a not guilty plea to the most recent allegations of violation.
That is correct, Your Honor.
Okay, I will accept a not guilty plea in the matter, and I will set it for a hearing. Now, the bad news for you is the other consequence of these 1,000 cases I have is this hearing will undoubtedly occur after the expiration of the PPO. What's this? Well, I mean, first of all, how many witnesses, Ms. Taylor, do you think you're going to be presenting?
2.
Yourself and Mr. Goins?
And I have one more.
Okay, so up to 3. So I'm going to guess that's going to take us a couple hours by the time I give Mr. Murphy some opportunity to cross-examine and time for argument here. Wendy, this is a hard question. When's my next 3-hour block that I could set for a PPO hearing?
Well, we can do May 22nd at 2:30, but
Not as bad as I thought. Let's grab that time while it's available. May the 22nd at 2:30 p.m.
Also, Your Honor, Ms. Taylor also filed a renewal of her PPO, that you
So that-
didn't, state anything on that as well.
Yep, no, I am looking here. Let's see. I see, boy, the violations and all the accompanying notices. Let's see here. I did get the oh. There's the extension. Yeah, and I did extend it. It looks like obviously back in April of 2025 to, as Mr. Murphy correctly pointed out, April 24th of 2026.
And then she just sent your office with the PPO office a renewed and got a document back saying that you stated that you would, after this conference hearing, or when it gets closer to that expiration, that you would then state whether you were going to
make
grant
a
it.
ruling. Yeah, that's what I usually do if I have an upcoming hearing. As I said, you know what, I'll decide it all in one hearing. In this matter, because I'm not able to push that, what I'm going to do in this matter, since it's my schedule dictating here, is I will grant a temporary extension until that date of the hearing that I just sent, May 22nd. That's only 1 month from the expiration date anyways, and Mr. Colby has been obeying the order thus far, and then I will decide both the question of the extension and also, and
I object because
Just a minute,
Mr.
ma'am, you're
Colby is
interrupting.
yeah,
Ma'am,
I
you're
don't have
interrupting the judge.
the extension just has not made its way into the request hasn't made its way into my paper file. It's probably in our electronic court filing system. I'm just flipping through the paper file that I brought home. When I get up to speed on this, I'll be able to review the extension. And then I think, I mean, my sense is I can decide that all in one hearing. Do you agree with that, Ms. Colby?
Yes, yes, I do.
If he comes on this property, I will kill him. That's
Ms. Taylor, do you think that I can decide that all in that single hearing in May?
I don't know because he keeps violating his PPO. I have to be worried to even walk out of my house. I have to have somebody walk me out because he's constantly stalking. No, this needs to be addressed. He needs to be violated for this. If he comes on this property, he probably ain't going to make it out alive because the cops take an hour and 45 minutes to get out here.
Totally disagree.
Well, yeah, I mean, and my only counseling to you on that, Ms. Taylor, and I get
That
it,
Murphy
right?
really has nothing to do with this PPO violation.
Well, no, and he's representing, Mr. Colby for the purpose of the PPO hearing here, and it's important, obviously, because Mr. Colby's the one, as I've explained to him in the past, who's at risk when one of these is in place against him, and if you
and nothing gets done about it.
well,
he's
if
already
violated, all I can
violated
say is I have
14 PPO.
Well, I have, and I believe there was one case in the past where I fined him a couple $100 on a violation, and I think what I'm hearing
that's
from you
just a
is
slap on his hand.
okay. Well, but nonetheless,
So if I come up missing, it's okay.
No, of course not. But that's not what's before the
Something
court
needs
now.
to be
So,
done.
Your Honor, we'd ask that she be
yeah, and here's the thing is right.
handcuffed.
What's done is the
I'm not talking to you, Mr. Murphy.
Yeah, is the enforcement of this thing, and I do want to mention to you, Ms. Taylor. Obviously, this isn't it's going to be a formal court hearing, and this is today as well, where we got to speak in sequence. It's not an argument per se, or us sitting at the table to hash something out. It's a very formalized and recorded proceeding where both parties have the right to appeal after I decide it. So it's important,
Your Honor, I just want to state to you
Mr.
that
Goins, I
Taylor,
don't want your statement because you're not a party, so you're out. So you just have to stay quiet. You want to file your own PPO? Go ahead and file it. But
He did, Your Honor. It was denied.
It's currently before the court. So anyway, that's what we'll do. We'll hold the hearing. The PPO does remain in place, and of course, parties are familiar with the terms of the PPO until such date that I will conduct a hearing. So I will see everyone on May 22nd.
Thank you, Your Honor.
Thank you,
Thank
Your
you.
Honor.
Okay, on to our next one.
That's going to be a great one, isn't it, Wendy? You're really hoping Lisa's back by May 22nd.
Yes.
I can sense it.
Okay, next is the matter of Gonzalez versus Gamboa, case number 26-30243-PH. This hearing is being recorded on Zoom and live streamed on YouTube.
All right, and this matter comes before the court today on the respondent's request to terminate a protective order that I granted. It looks like application and the order. Looks like I granted it on March the 4th of this year. So, and it does appear that both parties are present. What I'm going to do at this time is have both parties state and spell their names for the record, and then I will take testimony from the parties and make a ruling on whether or not the protective order stays in place. All right, Ms. Gonzalez. You filed this protective order, which I granted, and the basis you stated in your petition was I see. She has been harassing me since last week, February 23rd of, I assume that's this year, 2026, and had threatened me with her firearm and threatened my family. Can you describe more specifically how that happened?
Yes, so I had a confusion today about like the Zoom meeting. I thought this was gonna be in person, and I did have some evidence that like I wanted to present documentation of like statements that the respondent has said, and I think it's important for the court to review before like deciding whether to terminate the PPO.
Okay, and are those like printouts of text messages? What kind of documents do you have that you'd like me to see?
Yes, they're printed out screenshots of multiple messages that I received from the respondent. Yeah, I was gonna present them today, and I went to the court, but I was
Only
told
to
that there was
find
gonna
out the
be
hearing
through
was
Zoom.
on Zoom. Yeah, I do all my PPO hearings on Zoom because the court rules allow me to. Either party, just for reference, can request to have the hearing in person instead. The truth is I can get a lot more of these hearings accomplished if I go on Zoom, so I prefer to do it that way. And sometimes it's easier for the parties than getting down to the courthouse and parking. But I am more than willing to do them in person. I guess for purposes of today, Ms. Gonzalez, can you? You need to come up with 2 incidents of threats that she made to you. If you can read out loud what she allegedly said to you during those messages, then I can let Ms. Gamboa respond to that as to whether or not she really sent the message or not. And then maybe I can get far enough to make a decision today. I may still need to have you come in. So is it possible to read some of those?
Yeah, I have a total of 28 pages.
So it's a lot.
Yeah, it's quite a few.
Did you
But
submit
there
them to
is
OnBase or to the court ever? Because we do keep it.
no.
Okay, I was just thinking maybe I could pull them up if they were electronically in our file, but if they haven't, come through the door yet, then I won't have them available to me yet. Well, why don't you go ahead? And these are messages that came to you before you asked for the PPO on March the 3rd that were threatening. Do some of the messages threaten you with her firearm?
Yes, there was one message, and she said that I was going to get taken off the map. And also that she stated that she carries 2 firearms.
Okay, what's the date on that message, if you can tell?
These were in March 3rd.
Okay, same day you filed the request for the PPO, it looks like.
Yes.
And how do you know those are from Ms. Gonzalez?
Because she's messaged me through a personal account and her name is on there as well.
Okay, so it says what is it says Jasmine Gonzalez or what does it say? Or I'm sorry, how do you know you're Miss Gonzalez? How do you know this is coming from the respondent, Miss Gamboa?
Is it okay if I can turn the camera around and just
You can
show
try
you?
that. Sometimes we can see it if you do it like that. Okay, I'm seeing what looks like a printout, and you're saying it says right on the top there, Samantha Gamboa.
Yes, that's Samantha Gamboa, and then this is a comment that she made about threatening me.
Yep. And is that coming
And
in by
then
a text message to you?
yes, this is all these messages are through Facebook. And
Okay.
then here's another one where she said to be careful coming out of my house. And I have proof that she knows where I live, but I have never once told her my address.
Okay, and how do you know she knows where you live?
Because then she went onto my Facebook and you can see here Samantha Gamboa commented on my status and it says my address right here.
Okay, all right. So it appears in the comments on your Facebook page, wrote down your address.
Right. And she my pictures with comments about my address.
Okay, and taken in conjunction, where's the message that you said she sent you that said she carries 2 guns?
Right. This is right here.
Okay, and that says, love you should now I carry 2. Is that right?
Yes, I think she meant instead of saying now, she meant to say no. So, love, you should know I carry 2.
Okay, all right. Well, all right. So, and what you're saying here to me today in your testimony is that the combination of those messages and her knowing your address created what you perceive as a threat.
Yes.
Okay. All right. Is there anything, now you said you had some 20 messages there. Are they before or after the ones you just showed me?
So the ones that I showed you beforehand were back in March 3rd.
Yep.
Yeah, and then she's also just been posting my address all over social media.
I see. And what you're showing me now on the screen looks like it's dated March 3rd and it's the photo of a front of a house. Is it your house?
Yes, that is my house, and she's posted that on social media. And you can
And it
tell
says
here.
when you played too much, what is the next part of it? I can't quite read that.
It says when you played FBI too much, Stank needs a whooping.
Okay. And that again is originating, you believe, with Miss Gamboa going to you.
Yes.
Okay. All right. And it also occurred on or about March the 3rd when you asked for the order.
Um, um, I would also like to show you something very important because whenever she has served those papers right back to me, terminating them, She's also, I've read the note where it says she's pursuing a nursing career.
Yep.
And I would like to just put this out there that she somehow, I have no idea, found out that I was in Pine Rest hospital for a while. And if my sister, she told me that that's exposing my health information, and it's going against HIPAA regulations, which is made to protect everyone's health information. And
Did she mention the fact that she stated that you were in Pine Rest on this same exchange? I mean, is this on some of these messages?
yes, so she's also made she's messaged me that right here where it says Pine Rest as ho. And
What's the date on that
after
message?
that, this was March 4th
Okay, so
at
after,
7.
yeah.
Yes, this
So
is
that'd be
after.
after you applied, maybe after she got served, after I signed it and issued the order.
Yes.
Okay.
And then she's also made a fake page about me impersonating me and putting my health information out to people to know, which that says here in the comments.
Okay, what's the name of the page that's impersonating you?
It's called Jazz GR Community 8.
Okay, and how do you know that
But
Gamboa made it?
right. So it says here, sorry. So whenever she's got served, which was 3/9/26 at 3:49 p.m. This is a confirmation picture of the PPO being served
Yeah.
and signed off. Keep in mind that was on the 9th.
Yeah.
And then this is the account that she made. She's had 522 followings and quite a like 56 postings of me. And the reason why I believe that
Can
it
you
is
tell when
her
she
is
created, I'm sorry to interrupt, but can you tell when she created the page or the account?
no, that one I couldn't take a screenshot and print out, but right after she's got served, I did receive a message from a friend of mine saying that the page did not exist anymore. And this was the day after she got served, which was March 10th.
Okay, so really you don't know for sure if she created that before getting served with the PPO or after, because you just can't tell from the Facebook page.
It was an Instagram page, but I'm more than confident to say that it was her because the comments that she made on all of these postings is something that she's already said to me in messages directly.
But you can't tell when she posted it. It doesn't have a date.
Like a posting.
Yeah, any date identifier, and it's important because the stuff that happened before is the basis for your protective order, and then things that happen after, if I continue the protective order, you can raise them as violations potentially, but they can't support the protective order because they didn't happen until after I signed the protective order. So that's the importance of the date.
Right. This see this picture? This was on the 4th.
Okay, which would have been golly.
The same one she posted on that fake page.
Yeah, which looks like maybe she was served with this on the 4th because I think that's what the proof of
Yes.
service says. Yeah, okay. Well, that's the date I signed it, and right, she could have been served with it that same day. So, okay, no, I think I understand what you're saying, and it sounds to me like what you're identifying the two threatening incidents, being those messages on the 3rd that say, I think you should be taken off the mat. Stank needs a whooping, and you know I carry two. Those were the threatening messages in conjunction with her identifying your address that that spurred you to get this PPO.
Yes.
Okay, all right. Well, let me give Ms. Gamboa an opportunity to respond. So, Ms. Gamboa, if you would please unmute and then raise your right hand. All right, thank you. And Ms. Gamboa, you respond to this asking me to terminate it.
Correct.
Apologize here. I'm paging through the different filings and submitted a letter. And I take it from you, I'm reading down in your letter here that prior to the incident, the petitioner communicated with me directly and provided her address, I take it, encouraging a confrontation. And that then, I guess what I'm trying to get, Ms. Gamboa, is what's your version of what occurred? It sounds like from saying that maybe you're saying, well, she started it.
Your Honor, I take this situation very seriously. I understand the purpose of a PPO order. However, I believe the situation was a mutual and not one-sided. The petitioner also engaged and used aggressive communication and encouraged a confrontation. I provided you with evidence. I'm currently focused on my education and pursuing a nursing career as a nurse anesthetist. I almost didn't have time to make it today. My schedule is super busy with school and work. But yes, I did provide you with some evidence that she provided addresses and told me to come, and I did not go. So I believe that this was mutual. I've never seen her in person. I never met her in person. We don't go to the same places. We're not in the same circle at all. So therefore, that's why I asked for this.
Okay. Well, yeah, you're asking me to terminate it now, but you're not denying. Did you post the messages she cited about I carry two and Stank needs a whooping?
Yes, I take responsibility for my part, but like I said, it was a mutual exchange. Ever since then, I blocked her, and I don't have any intention in having further contact or arguing or doing anything of that sort. I just want to move forward.
Okay, and I take it you're saying that the confrontation, because what I'm looking at here is the documents that you submitted objecting, and yeah, there's this page popped ass peasant. Are you saying is that your page or is that
No.
Okay, you're saying that is
That's her.
her. Okay.
Yes.
And these are exchanges, and I'm looking here, March 2nd at 8:04 a.m. I'll be solo, pull up though, IDGAF, 3 p.m. Aha, never gave scary or pussy watch. Yeah, right. We'll see, fat F. You're a peasant. There's back and forth going, and I think what you're trying to tell me is that on March 3rd, when this conversation continues, it's simply an escalation or a continuation of a verbal or online electronic back and forth that had already been started.
Correct. But after that, like I said, we blocked each other. I blocked her, and didn't have any contact with her.
Okay.
And I was served. I know you guys were talking about that earlier, and I was served the 9th. I wasn't served that exact same day. I wasn't served the next day. I wasn't served the next day. I was served the 9th.
I see. So you didn't even know that there was a protective order against you until it was delivered to you. Yeah, it looked like I maybe signed it on the 4th. I don't have the proof of service here. Okay, all right, and
In your honor,
yep.
this is, like I said, this is very, very important to me because I mean, this is my career that I'm talking about, and in the heat of the moment, I was upset. But I learned and I grew from this experience. And it was a very tough time, but I don't want to go through it again, and nor do I want this on my record.
Yeah, no, well, here's the good news for you. These are civil matters. They don't ever show. The only time they would show on any government record is if the police run a lien check because they come to a call, alleging a violation of one of these things. They can see that the order exists. But when the order expires or is dismissed by me, whatever, it goes away. And unlike a criminal record, which is recorded by the state police in our, the database, this does not remain there forever. It's unlike that, in other words. And, employers can ask you if you've ever been convicted of a felony, but generally they do not ask you if you've ever been subject to a protective order or things like that. And that's because they are civil matters. They are not as serious as a criminal matter. Now, I don't want to downplay it. If I put one in place and it stays in place, well, then you can get charged with a felony aggravated stalking for violating it, and it can get you in a lot of trouble. But the other piece of it is even in a worst case scenario, when I grant these and they stay in place, and the reason I typically grant them for 6 months is recognizing that a lot of times when people see these and legal documents start being exchanged, all of a sudden both people say, you know what, it's not worth it anymore, and kind of back away from the situation. And that may have happened here, and in that case, it kind of satisfied the the intention of the order. So and I hear what you're saying is whatever you do, Judge, I don't want it to interfere with my future career aspirations. Where are you in that educational process now?
So I'm very excited to start in winter for my nursing program, and therefore I do need to submit a background check for that. That's why I'm like very, very, very serious about this. I do
Sure.
have a whole plan. I'm sorry.
No, and you said winter. I mean, so I'm taking it fall next winter or this year?
Yes, next, like basically next year. Yes.
Okay, so in the fall term,
Yes.
that would be when that would start. Oh,
Correct.
okay, I understand. I don't think this is gonna even touch that because of its nature, but nonetheless, I do understand your concern. Let me return to petitioner in the case here and hear from Ms. Gonzalez again. Ms. Gonzalez, you said you saw the letter. Did you see the attachments to the letter that under this Popdas peasant webpage or not? So webpage, maybe a Facebook profile. I'm not sure what it is. Apologize for my lack of social media currency. Did you see those attachments?
Yes, I seen them all.
Okay. And I think what Ms. Gambo is arguing today is, look at Judge, I did say stuff that I now regret. However, it was in the context of this back and forth online. That what was a back and forth, and that it looks like you're responding here too, and saying things back to her. What's your response to that?
So there was a point, where she kept messaging me and I told her to leave me alone. And she kept going right after I said that. Yeah,
Okay.
so I told her that she was annoying me. Like at that point, she was just going to get ignored. And she then proceeded to text me after I blocked her on Instagram. This is Instagram.
Okay.
After I blocked her.
And when you're saying this, you're referring to the documents that Ms. Gamboa attached screenshots of to her letter. Is that what we're all talking about here, this Popdas peasant series?
Yes.
Okay.
She then proceeded onto Facebook So honestly, I don't believe that she would, not keep going after this because um she had only deleted that Instagram page because she found out that she was getting served with the PPO. Otherwise, she would have kept posting because I have a video recording of the entire page she made about me, and it says the dates and the timing. So every day she would make a posting about me.
Okay, and all around the same time frame of March of this year.
Yes.
Okay, all right. Well,
And I also do not believe that it's okay for someone who is in a nursing career to put my information about me being in Pine Rest Hospital out for the public because that is violating HIPAA regulations.
well, certainly could, and and I will say certainly, that's the kind of information that qualifies as harassment, and that's what about these protective orders is the essential goal of the protective order is to keep the two parties apart from each other so that things don't escalate to being, hey, meet me at such and so an address, and they turn into a fight or a gunfight or a knife fight or anything else. The law's desire in this thing is, I sometimes say it's kind of like a boxing match or a kickboxing match where the referee says to the two people that are fighting, hey, you two get back to your corners and you just stay there. No swings at the other person, just stay in your corner and let this thing cool off a little bit. And, that's what, anyway, we hope they do. And, it sounds like it might be working here, but the facts that were testified to today before the court and establish that, on or about early, late February, early March of this year, that there was an exchange, maybe several exchanges between the parties here on various electronic platforms, including, apparently Instagram and Facebook. And the plaintiff responded by, or the petitioner here, Ms. Gonzalez replied by filing a request for a protective order, stating that she had threatened me with her firearm and threatened my family. She has found where I live and has been posting my address on social media. And just now she's been texting me and told me she is outside my house. I do not feel safe, especially when I've been threatened countless times with her firearm. And to support that, the court was shown messages today that did indeed say, threatened to take you off the map and know that I carry two, which, perhaps in street language, certainly, when we refer to carry, I take that as perhaps you're exercising the ability to carry a concealed weapon and doing so. Given those messages and then subsequent messages that do say Stank needs a whooping, with a picture of the house where the petitioner, Ms. Gonzalez, lives, I certainly can see where, in a reasonable person's mind, that would be considered threatening. Now, Ms. Gamboa has appeared today and supplied additional messages to the court and also a letter saying basically I'm not maybe the crazy person depicted by these exchanges here, but rather, Judge, I want you to understand this was in the context of a mutual exchange online where things got heated on both ends. And I agree that it was. However, I do have to recognize that Ms. Gamboa, it was you that escalated this, with saying you carry, implying a weapon and also posting the address, which I didn't see in the other messages that you posted that, you know, she was outing your address or doing those things. There were threats, you know, back and forth and shut up and name calling and things like that going back and forth, but not, you know, it escalated when there's a threat of a weapon. So I do think that two incidents occurred online in this case that would justify continuation of the protective order as it's written. And after all, you know, they're not major limitations on your life except with regard to the protected individual. And secondly, with regard to purchasing or possessing a firearm, they do limit your ability to have a firearm in your possession during the time that the protective order is in place. And because the threat here is about carrying, I'm inclined to leave that firearm provision in here. So I am going to allow the protective order to continue at this point. As I said, I write these for 6 months, and this one therefore expires, I think, in September. Or the expiration portion of it. Yeah, expires September 3rd of next year. So this will expire about coincidental with the start of that nursing program. You know, I would counsel you, Miss Gamboa, you do seem to be, you know, a person who thinks about the future and things like that. This falls into a broad category of things that are simply not worth it to mess with the protective order while it's in place. Just, you know, the definition of contact in here, because it does say you can't contact the person by telephone or send mail or other communications to the petitioner. While the definition of contact is very broad because it references another Michigan statute, which basically says if you post on social media or if you send something to someone else on social media and you know they're going to forward it to the person, you know, with the intention of getting their attention, you know, that can be construed by me as you contacting them. And the way that happens, if Ms. Gonzalez feels like you violated that by something that you posted or something stated online, is that she would bring a you know, alleged violation in front of the court, and then you'd be entitled to a hearing as to whether or not, you know, whatever was posted did violate my protective order. And I always tell people, and you know, if I do find that you violated, the penalties there are up to 93 days in jail and a $400 fine. So it's way easier just to say, okay, we're going to take that neutral corners at this time and not have any contact with each other. You know, sometimes these people that file these live like, you guys aren't like neighbors, are you? Like not right next to each other, or I mean, I do know you both have Northwest addresses, but it doesn't sound like you would run into each other every day walking your dogs or anything like that. So, you know, I you know, tell most people it should be pretty darned easy to obey the terms of a protective order, because it basically says, you know, obey the law, you know, don't pester this other person for 6 months. And as it comes up to that 6 months, if Ms. Gonzalez feels like there is a basis for continuing the protective order, and that basis the law defines as another violation of the protective order that occurred between now and then you can ask to extend it, or it just automatically expires and I remove it from the lien system and it is no longer an issue. So that's what I think both parties' goal ought to be here. There was a online blow up. Fortunately for everyone, it didn't result in any sort of physical confrontation or anything else, because you know, it's always worse. And you know, I always applaud parties for turning to the court and saying, hey, you know what, I'm angry about this, but I'm going to handle it essentially by filing some paperwork rather than by you know, actually going to your house and knocking on your door in the middle of the night or something along those lines. So it is a preferred way of resolving things, even though it's not perfect. So any questions from me from either petitioner or respondent? I'll give you the first chance, Ms. Gonzalez.
So, I guess I just want confirmation that the PPO will remain in place.
It will remain in place till September 3rd of this year.
Okay, thank you.
Thank you. And Ms. Campbell, any questions for me at this time?
No, I just want to reassure you that I did not make any contacts to her since I received the PPO order. I just
Good.
want to make
No.
that very, very clear.
No, I appreciate that, and I don't have any allegations that you violated yet, and of course those would all come up after you've been served, and you identified that service date as March the 9th, so that's when that takes effect regarding you, is when it's actually in place. And I'm grateful that you didn't, like I say, you've got everything to lose the way the PPO works if you violate. So even if something does bother you, or you think someone's trying to get under your skin, always best to just document it, so that if we have that hearing to continue, you can bring that in front of me, but don't respond to it. I know it's a hard thing to ask, but nonetheless, I try to make these fair for all the parties, and that's my goal here, and simply keep everyone safe is a important second goal. So that's what we're trying to do. I appreciate both of you showing up and speaking very clearly on your own behalf and bringing in evidence today. That was very helpful. So thank you very much. Both of you have a safe weekend. And like I say, it will remain in place till September, upon which it'll expire unless Ms. Gonzalez submits ahead of time for an extension.
All right, thank you, Your Honor.
Thank you all.
Yeah. And Rossi is finally stopped telling stories for now. For now, ladies and gentlemen, there's more Rossi. I did the thing again, didn't I? I got to get used to this new setup. I just can't do it. I keep turning my mic down instead of the music, and it drives me crazy every single time. Oh man, there's gonna be more Rossi. I'm sorry, I didn't mean to clear my throat right in your ear. I do apologize for that. I turned the volume up so I could do that for you. Wow, all the things. Remember what I said about preparation earlier, ladies and gentlemen? There we go. All the things are wrong. I did none of the things right. Tonight, ladies and gentlemen, we have a premiere with Judge Hesseling. That is, it's older, it's longer, it's good. Come on by. About a dad who's recently gotten out of prison, who really wants some time back with his kid, but he has no good plans on the table, and Judge Hesseling wants to have a long talk about it, and his ex is present. So it's a big thing. The premiere is up right now. The link is up and live. Tomorrow night, ladies and gentlemen, I think we're probably going to be watching a premiere of Judge Webster with a soft sit from this past week. I hope y'all will be here for that. If it's not that, then it might be another Judge Rossi. But we might save Judge Rossi for next weekend. I'm not sure. Hadn't made up my mind yet. For me, from the dog, thank you so very much for hanging out with us today. I have had a wonderful time with you, chat. You have been lively as always. I do want to give a special shout out to Nina out of the Blue Zach, my good friend, Raw Nerds Unite, Scott McIntosh, 2 times over, my friend. Thank you so very much, guys, for all of the support. And all of my friends in chat, all the lurkers out there, you're all so wonderful. We have drops every single day of the week. We go live every single night with a daily case review at 8 p.m. Central Standard Time, 9 p.m. Eastern. But come on by and hang out with us. If you don't hang out with us all the time right now, kind of like Hermeticus does, and Julie, and all of my great friends in chat, Kiernoff, Tev, Julie, Mama, well, she's Mom, right? Eileen, all you guys, been around with us so good. Thank you so very much. Whitsom, out there somewhere, maybe not here right now. Rhonda, out there, everywhere, always, all the time, watching the weather for us all, keeping us all safe. Be weather aware, by the way, ladies and gentlemen. But for now, Until later on this evening when we have a premiere and another live chat and another interesting case to watch, I am your lone wolf Uso. I am your host for this here channel where we curate, archive court cases from around the internet and around the country. And for now, I am out. Y'all have a great day. Have a good Saturday. Thank you so much, guys. Yeah. Ferris Bueller never gets a day off. Not how it works. Just remember, guys, the difference between stupidity and genius is that genius actually has its limits. See you later.